Welcome to the deep dive.
What if? Right. Today we're diving into exactly that, efficient understanding.
Ooh, I like that.
We're calling it
Hit me with it.
mindful moments.
Oh, okay.
Not just like, those fleeting thoughts you have, but like these concentrated bursts of clarity on these complex subjects.
So what if I told you that almost everything we argue about with the Second Amendment today, well, it kind of misses the point of where it all started.
That's a great place to begin because the history is uh, genuinely surprising. It's not this fixed thing people imagine.
Exactly. It's shifted, it's evolved right alongside the country itself. So let's jump back. Think April 1775, Boston.
Right. An occupied city, British troops everywhere. But outside the city, something else is stirring. The militias.
And these weren't just angry farmers with pitchforks, were they?
Not at all. These were, pretty well-organized military forces, actually baked into the colonial government structure.
Baked in how?
Well, essentially, every white man, aged 16 up to 60, was required by law to be in the militia, and crucially, required to own a weapon and train.
So a civic duty then. Less about personal self-defense, more about community defense.
That was definitely the emphasis, and it tied into this deep, deep suspicion of standing armies.
Why this is...
They saw them as tools of the government, potentially tyrannical. You even see quotes calling regular soldiers the dregs of the people, totally disposable by the state. The militia, though.
They were the people, the virtuous citizenry, armed.
Precisely. Which leads us directly to Lexington and Concord. That wasn't just a random skirmish.
No, it sounds like the militia system activating, a coordinated response.
It absolutely was. Thousands of militia members, organized in regiments, responding to the British move. Historians stress these were established military units acting.
Okay, so the militia ideal was powerful, but the Revolutionary War itself, that started to reveal some cracks, didn't it? Particularly for George Washington.
Oh, definitely. Washington arrived expecting, let's say, a certain level of discipline based on the ideal. What he found was different.
Different how?
He was quite frustrated, frankly. Lack of order, inconsistent obedience, even basic sanitation issues in camps. He had that famous line about Massachusetts officers being nearly of the same kidney with the privates.
Meaning not much hierarchy or professional conduct?
Exactly. And this experience, this reality check, pushed towards creating the Continental Army, a more professional force.
So the reliance on the pure citizen soldier ideal began to wane.
It had to, for a long war. By Yorktown, the final major battle, militias were only about a third of the American forces.
That's a significant shift.
It really is. It shows this tension. The citizen duty versus the need for a professional, disciplined army. And that tension feeds right into the debates over the Constitution.
Right, because after the war, they had to figure out how to structure this new nation. And military power, federal versus state, was a huge sticking point.
Absolutely huge. You had the anti-federalists, people deeply worried about a powerful central government.
Who were they, broadly?
They were the group opposing the new Constitution, fearing it gave too much power to the federal government at the expense of states and individuals. Figures like Luther Martin.
And what was Martin's specific fear regarding militias?
He worried Congress could basically federalize state militias, march them anywhere, override state control. He literally warned about Maryland's militia being sent to the remotest part of the Union.
So the Second Amendment grows out of that fear, protecting the state militias from federal interference.
That's a core part of its origin story, yes. Which brings us to the wording. A well-regulated militia being necessary to the security of a free state. What did well-regulated mean back then?
Good question. Not necessarily lots of laws, right?
Probably not in the modern sense. More like well-functioning, properly equipped, trained, disciplined. Some early drafts even said well-regulated and well-armed.
Interesting. But then the Senate made a change, didn't they? They took something out.
They did. They removed a phrase describing the militia as the body of the people.
What's the implication there?
It perhaps subtly shifts focus away from every citizen being the militia towards a more distinct state-controlled force. It adds to the ambiguity.
And then there's that whole opening clause, the preamble. Does it limit the right that follows or just explain why it exists?
The million-dollar question. For centuries, that's been debated. Back then, preambles often had real legal weight. John Jay pointed out, they could clarify intent.
And the fact the Second Amendment has this kind of explanatory intro, unlike others in the Bill of Rights.
Strongly suggest it was considered important, yeah. Not just fluff.
Okay, let's move forward a bit. The early republic, the Jacksonian era, the country's changing, becoming more individualistic. What happens to the militia idea?
It starts to fade, that sense of mandatory duty, and you see a rise in, well, individual gun ownership and associated violence, things like duels, carrying weapons openly.
And ironically, the first real gun control laws pop up then.
Yes, aimed specifically at concealed weapons, like pistols and daggers. And in reaction to those laws, you start hearing arguments for an individual right to bear arms, specifically for self-defense. Some states even add that kind of language to their own constitutions.
A real shift in focus. Then comes the Civil War, a massive upheaval. How does that reshape the gun issue?
It brings race violently to the forefront. After the war, in the South, you have the Black Codes.
What were those?
Laws designed to control newly freed African Americans, essentially trying to recreate slavery. And a key part was disarming them systematically.
Well, white supremacist groups were armed and committing violence.
Exactly, like the KKK. It was terrifying. You even have petitions from black citizens, like in South Carolina, pleading for the right to be armed just to survive, to have equal protection.
And the 14th Amendment was supposed to fix this, right? Guarantee equal protection, including, presumably, the right to defend oneself.
That was the clear intent. Protect the fundamental rights of these newly freed citizens against state abuse.
But the Supreme Court threw a wrench in the works.
A big one, U.S. v. Cruikshank in 1876. The court said the Second Amendment only restricts the federal government, not the states.
Wow. So states could still disarm people, particularly black citizens, despite the 14th Amendment.
It severely hampered federal efforts to protect those rights at the state level. A major setback.
It's fascinating, though, that even during the so-called Wild West era that followed, gun control wasn't unheard of. Places like Dodge City.
Right. Famous sign. Leave your revolvers at police headquarters. The image of everyone constantly armed is maybe more myth than reality in some places.
So gun laws existed, and then in the 20th century, we see the NRA evolve. It didn't start as a political powerhouse, did it?
Not at all. Founded in 1871, its main goal was marksmanship training, improving skills for soldiers and militia veterans, often with government support.
Focused on skill, not politics.
Initially, yes. After World War II, the focus broadened to hunting and sports shooting. Still not primarily political.
Until the 1970s.
Until the revolt at Cincinnati in 1977. There was a major internal shakeup. A more politically motivated faction, focused on a very strong interpretation of the Second Amendment as an individual right, took control.
And that led to the NRA we know today, focused on lobbying against gun control.
Pretty much. It became a highly effective political force advocating for what they see as Second Amendment rights, generally opposing most regulations.
And this political shift happened alongside a long period where the courts didn't see the Second Amendment as an individual right, correct?
For decades, yeah. The legal consensus, based on cases like Presser and Miller, was that it was tied to the militia.
But then a new legal philosophy gained traction. Originalism.
Right, pushed heavily by conservative legal thinkers like Edwin Meese in the Reagan administration. The idea is to interpret the Constitution based on its meaning at the time it was written.
How it was originally understood.
Exactly. And there was a subtle shift within originalism itself from trying to figure out the framer's specific intent to looking at the original public meaning.
Meaning, how would the average person back then have understood the words?
Precisely. It's less about mind-reading the founders and more about the common understanding of the language. Exploring different interpretations and the context, like you might see on channels such as Mindful Moments and our podcasts that analyze historical texts, really helps grasp these nuances.
That distinction seems crucial, and it paved the way for a landmark Supreme Court case, Heller.
District of Columbia v. Heller, 2008. A watershed moment, absolutely.
Because it was the first time the Supreme Court said
that the Second Amendment does protect an individual's right to possess a firearm, unconnected to militia service, specifically for self-defense within the home.
And Justice Scalia, writing the majority opinion, leaned heavily on that original public meaning idea.
Very heavily. That was a core of his argument.
But the decision wasn't unlimited, right? Scalia acknowledged some regulations could still be okay.
Yes, he explicitly mentioned things like prohibitions on felons owning guns or carrying firearms in sensitive places like schools were likely still constitutional. But it didn't draw super clear lines.
Which led to more lawsuits.
Naturally. A whole wave of challenges trying to figure out the boundaries, especially around carrying guns outside the home.
And different judges have different approaches, even now.
Oh, yes. You see debates about methodology. For instance, Now, Justice Kavanaugh, when he was a circuit judge, advocated strongly for relying solely on text, history, and tradition, rejecting balancing tests that weigh public safety interests against the right.
So the legal landscape is still very much in flux.
Definitely. And since Heller, we saw the McDonald v. Chicago case apply the Second Amendment to the states via the 14th Amendment.
Right, so states couldn't infringe on that individual right either.
Correct. And politically, things have become incredibly polarized around guns. Heller fundamentally changed the legal and political debate.
And adding another layer of complexity, actually studying gun violence has been difficult.
Yes, for years there were significant restrictions on federal funding for gun violence research, making it harder to gather comprehensive data to inform policy.
So we've covered a lot of ground, from colonial militias needing muskets for civic duty,
Through Reconstruction and the fight for black citizens' right to self-defense.
to the rise of individualism, the NRA's transformation, and finally the modern legal battles, starting with Heller.
It's clear the meaning wasn't fixed. It responded to the times, to societal needs, to legal philosophies.
It really makes you think. The story is so much richer and more complicated than the sound bites we usually hear.
Absolutely. It's a story of evolving rights, technology, and societal fears, all wrapped up in those 27 words.
Which leaves us with a really challenging question for today, doesn't it? How do we take this history, the militia context, the self-defense evolution, and apply it sensibly to our world with modern weapons and modern problems like widespread gun violence?
That is the question. There are no easy answers. But understanding the journey of how we got here, the twists and turns in interpretation, is surely the first step.
A crucial step. Well, if this journey through the Second Amendment's complex past got you thinking, make sure you subscribe so you don't miss our future explorations.
And share this discussion. The more people understand the history, the better our conversations can be.
Absolutely. And if you want to go even deeper, the book The Second Amendment, a biography by Michael Waldman, offers fantastic detail. We'll put a link in the description.
But most importantly, keep questioning. Keep thinking critically about how history shapes our present understanding of rights.
Couldn't agree more. Thanks for listening.